Utilizing the provisions of Section 18 of the Prevention of Organized Crime, prosecutors seek to deprive accused persons of any benefit they derived from committing crime by obtaining a confiscation order following the conviction of the accused. Since 2011, prosecutors have moved 1,326 applications to confiscate proceeds of money of more than 116 million, over 160 million. The proceeds were paid to the victims of crime or into the criminal asset recovery fund. How are we addressing organized crime? Gangs is an issue in the Western Cape. We've seen it in our court rolls, we've seen it in the lower courts as well. Organized crime is prevalent. Consequently, we have dedicated prosecutors who work with the GPCI to address this. I indicated earlier that I'm not going to discuss pending cases. However, you are aware of several matters that are pending in our courts relating to the extortion of businesses, kidnapping, and attacks on members of the criminal justice system and legal representatives. We've got a list of these cases as well. You know that one does not address organized crime in the media. The work happens behind the scenes. And it is only revealed when the police act and when persons are brought before courts. Gender-based violence, including sexual offenses, including femicide and domestic violence, are central focus points. In addition, the focus that we have are on vulnerable groups. These vulnerable groups include children, where we deal with pornography cases, children in conflict with the law, senior citizens, mental health, both for victims and accused, the LGBTQI group, as well as hate crimes, persons at risk, including human trafficking. We've got dedicated forums made up of senior public prosecutions and ad hoc external stakeholders addressing these crimes against these vulnerable groups. The following are some of our initiatives. Dedicated sexual offences prosecutors who serve the dedicated sexual offences courts. Our sexual offences and community affairs unit, known as SOCA, in rolling out case managers to assist with prosecutors with the screening and consultation. We've got our Tutuzela care centers within the province. We've got 7 Tutuzela care centers. Next week, we're launching an 8th one at the Weinberg Victoria Hospital. I'm sure Eric has already invited the media to that launch of the TCC next week. If not, he will send out the invite today. We also do review of our capacity to address sexual offenses, including GBV. We're all aware of the DNA and the delay and challenges there was with DNA. The MPA has embarked with SEPS on a special DNA project. This is now a national project to prioritize DNA analysis in sexual offenses. This has had a positive impact on our finalization and conviction rate. The success of this drive now resulted in a similar drive for murder offenses. All cases where children died under suspicious circumstances are escalated to the DPP office for screening, on which we sit also on child death reviews with some of our other stakeholders, including the pathology labs. The DPP also monitors all mental observation referrals of accused persons in this province. Murder is a serious matter within the Western Cape and the Cape metropolitan area. This is particularly notorious. For this reason, uh, prosecutions in the High Court in murder matters are key priorities for us. The High Court has, like all the district and regional courts, been impacted by the COVID-19 pandemic, and we have developed a backlog of cases. To address this, the judge president has created 4 additional divisions or courts to complement the existing 12 courts that we had to work through this backlog. To increase the High Court footprint, the judge president has also designated additional circuit courts, including a High Court at Pollsmoor Correctional Center. This affords us an additional opportunity to finalize prosecutions more speedily. We have finalized 35 cases on the High Court roll, largely due to the extra divisions or courts the judge president has created. These 4 extra divisions are run on a fast track basis with shorter trials allocated on these roles. At the start of our term, we had 27 parted matters on our court roll. The prosecution has had several recent notable finalizations in the High Court, which Mr. Ntabazila has reported on. We also have this information available should you have missed it. We have a murder prosecutions initiative in the DPP office. We have screened 397 murders, and we are actively guiding 103 of them. 44 of these cases have been identified as possible High Court cases. Femicide matters are of particular importance, and we continue to monitor them throughout the journey in the criminal justice system. A system has been implemented whereby prosecutors engage shortly after the matter is enrolled. The aim of this engagement is to advise them of the various contact persons in the process and to explain the criminal trial process. In respect of our murder bilateral with SAPS, this is a project designed to investigate the following type of murders. Murder where there have been no arrest and no suspect, where arrests have been made, but the matter have been struck from the roll. The aim is to re-enroll these matters. Those matters where witnesses have gone missing or are reluctant to testify. With the murder project, we seek to achieve the following outcomes: to refer matters to the SAPS Cold Case Squad for enhanced further investigations, to exhaust all forensic tools to resolve crime, to monitor further outstanding investigation with a view to re-enrollment, to identify possible serial murder matters, to refer matters where no further action can be taken to an inquest court. In addition, we have requested SAPS to refer all murder matters where there are no current arrest to the local senior public prosecutor for perusal and guidance. In this way, we hope to ensure that all possible investigative avenues are thoroughly explored by the police at a very early stage. This initiative serves to focus on matters where there have been multiple deceased and femicides. The SAPS leadership has endorsed this, since we want to avoid dockets taking years before they receive the attention of the prosecutor. Murder is obviously a serious offense, if not the most serious that can be committed. I am mindful of the fact that the Western Cape has an exceptionally high murder rate, and I would be remiss in my duty if I did not appeal to the communities to assist the police in bringing perpetrators to book. The police and the prosecution must present credible evidence to secure a conviction. In most instances, we must rely on the eyewitness testimony of the community members to do so. In some instances, we are unable to proceed because no witnesses want to assist the police or they decide that they no longer want to testify. I appreciate that people fear for their safety and the safety of their loved ones. Prosecutors are therefore actively trying to allay witness fears in coming forward to report crime. By protecting the identity of the witness at an early stage and even at the trial stage where appropriate. In conclusion, I want to return to the issue of accountability. Currently, the main feature of the NPA's accountability is to the representatives of communities through Parliament. We in the MPA already have institutionalized accountability to victims of crime in several ways, including our representations process through which decisions can be reviewed. If a, com- if a complainant is not satisfied with the decision of the senior public prosecutor, they can write to me to review that decision. Similarly, if a complainant is not happy with a decision of mine, they can write to the National Director of Public Prosecutions to review any of my decisions. Another example is one I mentioned earlier in respect of the femicide prosecutions, where senior public prosecutors or regional court control prosecutors are required to, within 14 days of receiving my decision to prosecute, to consult with the deceased next of kin and advise them that the matter is being attended to and being prioritized. I, however, feel very strongly that we should be deepening our accountability to the communities at the coalface of service delivery. It is my decision that this division should have an accountability framework that permeates from my office to the court center level, since we are ultimately accountable to the people. In this regard, I have tasked my management team to develop a framework which is sustainable. When I have concluded our process and decided on an accountability framework, I will share that with you. Thank you once again for your attendance and joining online. The team and I will now respond to questions you may have. Thank you.
Thank you very much, DPP, for that statement. That was her final statement, sentence on the statement. And I'm opening up the floor now for any questions. May I please ask you to introduce yourself and from which media house you come from, and then mention your question. Also, those who are outside of this boardroom can also send their questions either through one of our social media connections. Thank you. Over to you, sir.
Aaron Hammond from the Sunday Times. Thank you very much for the opportunity. My first question, if I may just ask one or two questions. My first question is about Young and Alaka, the case that's also mentioned in the back of this briefing here, and Ayanda Isaka, two high-profile cases related to multiple murders in the province. My question is around how these individuals got bail on Schedule 6 offences relating to CIT crimes allegedly committed think it was 2018 and 2019 respectively. As far as I understand, in the Sarkos case, there's a pending matter before the File Magistrates Court where bail was never heard, and the matter it was never consolidated with the CIT case in the Eastern Cape. I know there's a problem with jurisdictions of courts and so on, but the overarching question is how these two individuals got bail on Schedule 6 offences. And then just a question linked to that is bail matters that where the MPA and the police successfully oppose bail in lower courts, in magistrates courts, and where bail is then overturned in high courts. What is the problem there? How does that tend to happen on a consistent basis?
Thank you.
Thank you.
And
And we are not going to discuss matters in detail that are subject, but we can talk around bail. Remember my notes I explained that each of you was going to. And in serious matters, like the matters you just mentioned, we oppose bail. But then it's discretion of the judicial officer to decide whether to give bail or not. I know at a particular case of those matters, what happened in that instance, but I'm not going to go into the finer detail because then we'll have to go into the investigation and we're not going to deal with that. Then your follow-up question dealt with bail appeal. Look, the accused has got a right to apply to appeal their decision. It's discretion of their court to see whether bail can be given. The court looks at it and determine on that basis. Remember, bail is also not an indication of guilt. And sometimes, and I'm not explaining to you, but more to the community. Sometimes people want if a particularly heinous crime is being committed. Oh, I'm told I'm muted. Sorry. Sorry. So shall I start over? Apologies. Just check me in future for other questions. I started off by saying that particular matter that you mentioned is sub judice. We're not going to go into the details of that fact, but we did oppose bail in that matter. I also explained in my note the accuser's got a constitutional right to apply for bail, and it's the discretion of the judicial officer to grant bail or not. And you particularly referred to Schedule 6 offences. Those are the more serious crime matters, but each matter has to be determined on its own facts. I'll ask Advocate Frister Simpson if she wants to add something. But then you had the later part of your question, bail pending appeal. The accuser's got a right to bring it. The court considers it. We are involved in that. We oppose in serious matters. The investigation officer is informed with it. Strict bail conditions is also set. Do any of my colleagues want to add to the bail appeal process or the cases mentioned? Please switch your mic off.
One of the critical aspects with regard to bail obviously is to ensure that the accused appears at court.
And that is one of the fundamental aspects that the judicial officer takes into account when considering, can the accused be brought to court on the next date of appearance. So when the state opposes bail, those factors are all placed before the court, and where the judicial officer decides that where there are sufficient other parameters that they can put in place, every day they do that. We must also understand that currently the correctional facilities are also quite full, so take that into account. But in these two instances, as the DPP has indicated, we're not going to deal with the merits of those bail applications. Thank you, DPP.
Any more questions?
if nobody else is there.
There is someone behind you.
Yes,
Yes, Mayur. Thank you.
I have a question regarding, it's a bit complex, I'm explaining so you can understand. My question is regarding prosecutors at different level courts and what conclusion or communication is when you have suspects who are facing multiple cases at different courts. So before building or if we have a gentleman, he's accused of murdering his girlfriend and dumping her body in a drain. He's appearing at Clone for that case. Subsequently, he's also appearing for the rape of the victim's minor sister at Weinberg. The police don't go to court and now decides he wants to resurrect his bail application. But when the family approaches the prosecutor, she's completely unaware that he's facing a pending matter at Weinberg where it was denied. His application was denied. Both of them obviously being very serious statements of Supreme Court. My question is in terms of how, because these prosecutors are at different courts about the same subject, is there a file or shared document? Is there a way that they communicate? Is there a regional mechanism? How does it work?
You would you to answer? Okay.
So this, the short answer to your question, ma'am, is that the prosecution doesn't have a system that tracks an individual of that nature. Because remember, some person appears in Athlone and he says, "I'm Tom Harrison."
Camera.
Sorry. The accused person appears in Athlone and he says he's Tom Harrison. Then he goes to Belleville and he's Harrison Thomas. So the names are not going to help us. That's why when a person appears in court, the police have taken his fingerprints. They've run his profile through their CAS system. And based on that information, we are able to make the linkages. So that is the system that we use. The police system is what we use to track individuals because they can change names, they can't change their fingerprints. So that's how we keep track of individuals. Thank you.
Thank you,
Thank you,
Advocate Mo.
Advocate Mo.
Any more questions?
Yes,
Yes,
please.
I'm from the weekend August newspaper. Just the issue of missing dockets that you have indicated in the presentation today. How
Because you've seen that course of that cases on courses as well. Also, that brings in a lot of other factors with regards to bail, etc. You know, this goes on, especially with just my colleagues mentioned as well. When that information is lacking in the docket sometimes, when the prosecutors get background information. How do you think of building that in the future, going forward, especially with homicide cases as well? Advocate Mr. Simpson, I will explain smartly. So,
dockets, when femicide matters are reported, all femicide matters are reported to the DPP office. We work on a scanned copy so that the docket remains at the court. So once we've read the docket or we've screened it, we will guide the prosecutor as to the further investigation, and that docket then works between the prosecutor and the designated police officer. At the DPP's office, we will request the docket at a much later stage after much of the investigation has been completed. And then we will take what we say a forum decision, and we will make a decision about where the matter is to be heard, either in the regional court or in the High Court. So the travelling of the docket between the SAPS and the prosecution, we try to limit as far as possible so that the investigating officer is always in possession of that docket for the purposes of investigation. With regard to missing dockets, again, the docket is handed back to the police officer, and he is required to present that docket to us again at the lower court tier with the further investigation completed. So the management of the docket sits with the South African Police Services and not with the prosecution in itself. We manage it working off the scanned copy and working off the docket that they present to us physically when they are at court.
There's a hand at the back.
Dr. Wenda?
To what extent your prosecutions are largely dependent on, or successful prosecutions largely dependent on the work that the police do. what extent are you guys working more closely with police to actually ensure that the detective work, that the paperwork is of a standard that assists the prosecutors in getting a relevant conviction? And the second question, just a point of clarity, on the DNA stuff, are you working with bank books, but are the red kits available in, let's say, for example, your TCCs, your TSA kits? Because my understanding is that there is still a shortage of these DNA red kits specifically. So when you say that you're trying to work to improve that, is it just the backlog that's already there, or are we rolling? Is there sufficient from your guys, from the female sexual, the sexual offences unit? Are you guys now seeing that the actual physical kits are sufficient, that they are there, and that at the police stations and with
I'll start with the DNA and the docket, Advocate Mr. Simpson. Let me just make sure I'm not. With the DNA, there has been an increase in crime kits. Uh, it, it's available, but not as readily available as previously. But there is a marked improvement in it, as well as the analysis of DNA as well. We are able to prioritize matter. If a matter is in the court roll and due to start, we can engage the lab to our national office, and that matter is given priority and the DNA is analyzed. So matters are no longer being struck from the roll because DNA analysis is not being done, because we're working closely. We're prioritizing the court dates with the DNA analysis. The first part of your question, Advocate Mr. Simpson will explain in detail. Explain the prosecutor-guided investigation model.
So the model that we work off when we receive matters is that we screen the matters and we draft the further investigation immediately. So that goes for all femicide, all multiple murders, all murders where there are firearms related, vulnerable groups are identified, children. The investigation gets drafted within the first 3 to 5 days that the matter is enrolled. We then ask the prosecutor at the lower court in some instances to monitor, but where we have determined that the matter is required, that we have identified a matter as a potential high court matter, we at the DPP's office, we monitor that docket. So we will request the docket to come to us, we will guide the investigation, and we will advise the police on what is still outstanding, what they need to do in order for the matter to be trial ready. So we actually take a lot of time to ensure that matters that are prepared for trial are done in a manner that will facilitate a prosecution and a successful prosecution at that. That is our ultimate aim, to ensure that matters are successfully prosecuted, that all evidence is followed up, that all outstanding investigations, forensic work is done immediately. And to that end, we've also engaged SAPs, and we've asked them to facilitate better forensic evidence gathering on the scene. So we've had bilateral meetings with them, and we've asked them, for instance, quite a simple thing is to enhance the photography on the scene, because that assists witnesses going forward, that assists them in placing themselves on the scene, what exactly they saw, the distances between where they were. All those kinds of things become very important in the trial process. So those kinds of things are in progress, and we are working already. And to
There's a hand behind you, Eric.
Thank you.
But I'm comfortable with the new whole small thoughts. Isn't there a separation between
Does it not worry you if there isn't kind of bigger separation between women and incarcerated and that?
time?
Thank
Thank
you
you
for that question.
Have you been to the facility at Portsmouth? It's it's on the premises of the Portsmouth facility. It's a separate court building. It looks like a court building inside as well, and it's purely for logistical purposes. We've explained our backlog as well, and the matters that we've done there were multiple accused matters and matters where accused are in custody. Accused is innocent until proven guilty. All those accused are also legally represented at the Portsmouth facility. Um, when the facility was set up, we visited it several times. The judiciary looked at it. I think legal aid also looked at it. There's facilities for members of the public to view the proceedings. There's also a link that can be made to the court as well, because we were concerned about accessibility for the public to the court center. The idea is when you're in court, you're regarded as innocent until proven guilty. That when the court was set up and we thought about it, that was paramount for us. So when do we have our next matter there? On Tuesday, there's a matter before court. Perhaps go and have a look at the facility and check the accessibility. Accused are in custody. It also assists with logistics in moving those multiple accused around.
Thank you.
Thanks,
Thanks,
Isabel.
Isabel.
I
I
will
will
I will
I
Can you
will
just mute? I'm a bit slow on the
I will
button.
I
send to
will
the
send to
media
the media
the
the
update on that
update on that
case
case
that's going to
that's
come
going
up
to come
on
up
the
at the
Portsmouth
Portsmouth
prison. It's a
prison. It's
matter
a
of
matter of
state
state
versus
versus
Mikhail
Mikhail
Davids and
Davids and
others.
others.
But
But
immediately after,
immediately after,
I think
I
over the
think over
weekend,
the
I will
weekend,
send
I
you
will
an
send you an
advice over
advice
the
over the
appearance.
appearance.
I
I
understand
understand
Mr.
Mr.
Hayman has
Hayman
got
has got
a
a
follow-up
follow-up
question.
question.
Yes, so my one follow-up question is about bail conditions.
Mm-hmm.
It's been explained now that bail
Mm.
conditions are obviously there to have accused present themselves to court again. In the Nyalaga matter, for example, as far as I understand, there was a bail condition that Mr. Nyalaga was supposed to present himself to the nearest police station that was in the border in the Eastern Cape. It was 2 years before he was arrested for crimes or murders that were committed between the time that his bail conditions were set
Both divisions.
and when he was arrested again. In, are the bail conditions, in your opinion, stringent enough for courts to more to protect the public, as is the case in these cases, for example?
It let me just remember it's the South African Police Service must monitor the bail conditions. I cannot speak on the facts of that matter because it's sub judice, and I can especially not speak on the Eastern Cape matter. But we have regularly instances where people don't adhere to their bail conditions. They're brought before court, the matter is heard, and they don't get bail. That's the procedure that is open to this. So it's not to the courts to protect, but it is for SIPs to monitor adherence to those bail conditions.
Sorry, I wasn't asking my question. Sorry, can I?
Go ahead.
Okay. My other question was about when convicts come out on parole
Parole. Mm.
at varying times, which I think the public has expressed their frustration with that in various cases. There's a recent case in Athlone where a suspect was arrested while he was out on parole, and he was arrested on exactly the same crime for which he was initially incarcerated. He is now applying for bail, and if bail is granted in that case, that, as far as I understand, will nullify the contravention of his parole conditions. Do you find this as prosecutors problematic? Is that something that should be addressed?
Would allow Mr. Bob to answer that.
No, I think your premise is wrong, sir. Parole conditions has got nothing to do with bail, because that's the DCS process. It's a correctional services process. They will make the determination what the parole conditions were, and if in their view parole was violated, they withdraw parole. That's at their discretion. That person will then be kept in custody regardless of what happens in court. So I think your premise is incorrect. Thank you.
Thank you, Advocate Mo.
There's a
There's a
hand.
hand behind you.
Yes, Jenny.
Question. Some of the worst cases that you've ever seen in your life are heard in the Western Cape High Court. How do your colleagues, how do you and your colleagues cope with this? Are you counsel? How do you deal with it? If you guys can take a couple of mental health days, how do
It's a good question. We do have an employee, Mr. Mock, employee wellness. We also try and arrange debriefing sessions for our advocates, our staff, but it will never be sufficient. Does anyone want to add to that?
I can add.
Please, Eric.
We don't end up in Falcons. Any more questions, colleagues? From the media?
Okay, thank you very much for
DPP for the opportunity. And